But then nobody reads the Zoom's terms and conditions, which are few pages long.
Right.
So it was I can come back to you, say unambiguous consent.
Or ambiguous consent. Yes.
Oh,
So,
yeah.
so yes, to the audience, since we are in a data privacy webinar, this session is being recorded. As Samir had mentioned, anybody who does not want this session to be recorded or may leave. Otherwise, it will be deemed to have you would have deemed to have consented.
Yes,
And,
that's the right way.
and the speakers, Samir and Dr. Limaye, the excerpts of this webinar will be put on our YouTube channels. In case you have any reservations, we'll discuss it offline, any which way. Right. Okay. Okay. Coming back. Okay. So it's nice, I think, discussion on data, sensitive data principle, data fiduciary, data localization, etc., etc. Now, Dr. Limaye, I think I can't say another heart of the issue, because yes, there are all important issues. But yes, one very big chunk of the legislation is data fiduciary and the obligations of data fiduciary under the Act. So if you could give an overview, because data fiduciary being all the companies who are collecting data. So what is it that these companies, because all these people, many of them would be general counsels, company secretaries, or head of HR, IT, finance, etc., CFOs or CEOs. What should they take care of? Like what does a data fiduciary need to take care of under the DPDP Act?
Yeah, so this is very tough ask, because first thing which every data collector or data fiduciary will be required to do is to send notices to all the data principals that we are fetching this much data, giving all the details that we are fetching this much data from you, for which they will also have to seek consent for fetching of the data. So first ask for all the companies, and where I think Complinity like companies will be benefited, that every company will be required to first serve notices to existing data principals that we have fetched this much data as of you, as of now, and if you don't consent for utilizing that particular data, kindly explicitly withdraw your consent. Otherwise, it will be presumed to be deemed consent and we will keep collecting that particular data. So, notice will be the heart of each and every data fiduciary right now. One first small correction is data fiduciary and significant data fiduciary. Not much difference, only as Mr. Samir mentioned, there will be some threshold limit. That is the only difference. But every data collector, even a small shop which is utilizing digitalized mechanism, like all pharmacy stores, now they have gone online. They are collecting information from the, or they are taking down prescriptions in electronic format, digital format, putting some name of medicine, referral doctor, etc. All these small utility centers to the big corporate social media sites, wherever data is digitally captured, will be termed as data fiduciary. So any and everybody on the now this particular business platform will be termed as data fiduciary, and they will be,
maybe you can take a minute to explain the difference between a fiduciary and a processor also.
yeah.
Data fiduciary and data processor.
Yeah, so very significant. That is not small. That is very huge difference or in data fiduciary and data processor. Data processor is the organization which is simply processing data. Means I, as a big organization, have subletted the task of processing or segregation of data, storing of data to some other organization. So that other organization is getting data from me. They are not directly connected with the data principals, but they will be termed as data processors. So they will be processing data according to instructions given to them by data fiduciary. So individually, they will not be liable for data principal. But as a data fiduciary, where I am collecting data, I am processing data, I am making some opinions based on that particular data, I will be termed as data fiduciary, and maximum responsibilities will be on this particular concept or term, that is data fiduciary. Data processor will have some sort of what we can say as intermediary guidelines, some leeway, some protection from the law, but data fiduciary can't escape the law. It will be the job of data fiduciary to send notices, to seek consent. And main thing which corporates must understand from day one is onus of proof will be on the corporates that they have obtained the consent, they have sent the notice. So this will be very huge ask, because if any dispute arises between data principal and data fiduciary, law has made it explicitly clear that the onus lies on data fiduciary to prove that he has obtained a consent, he has sent a notice, what information he has gathered. So, in a way, after this particular enactment of Act, data fiduciaries compliance part will be immense. They will have to keep register for each and every consent obtained from them, and Act goes one step further that these consents will be periodically renewed. That will be another huge ask, that renewal of those particular consent, noting it down, recording somewhere. So data fiduciary will have to do their homework well and adopt to the provisions of DPDP. And the legal team of any data fiduciary will be now required to work 24 by 7, because in-house they will have to put grievance mechanism before prior going to DPO, that is Data Protection Board. There will be one, say, agency or one officer which may be termed as grievance officer or data protection officer, who will be the main point of contact between data principal and data fiduciary. So every company will be again required to put up one DPO, that is data protection officer, who will be in charge of protection of this particular officer data, as well as compliance of all the data related queries. So data fiduciaries will be required to start their homework right from day one. That was from 11th August when Act was enacted, and most of the, hopefully, data fiduciaries have started this particular activity, because since Act is applicable, the day Data Protection Board starts its functioning, there may be thousands of complaints waiting for Data Protection Board for non-sending of notices, breach of data, etc., etc. So all the companies which will be data fiduciaries in a way or other, they will be required to take all the precautionary measures and all the compliance measures which are put up or set up in DPDP. So this should be the approach of data fiduciaries to this particular DPDP Act.
Right, right. So to sum up, Dr. Limaye, what you said is, one is the notice to be given by the data fiduciary to the data principal, that what kind of personal data I am seeking to collect, what is the purpose of this data, how you can exercise your rights for grievance mechanism, etc., etc. So that notice will become very, very important. Right. And second is the consent itself, that to obtain that consent for a lawful purpose, basically. Now, for example, the practical implication would be like, just to start with an employee only. An organization hires an employee and collect the entire detailed candidate information form and all the mark sheets and all the sort of family members and mobile numbers and bank account numbers and everything, including biometric and medical records and everything. So I think that data, what Samir was explaining, that if it is kept only in a physical paper, it is outside the purview of the Act. But if it is even PDF, even if it is scanned and put up on the server, or if it is digitized on a HRMS software, or in whichever other format, it will come under the purview. And all the organizations to start with must ensure that either you already have a consent, or now you go back and ask your employees for the consent, that okay, I have this information about you for this lawful purpose, and please provide your consent. So this will become a very gigantic exercise. But although I also see that just like in software downloads, we have noticed that when you're downloading an Adobe, or you're sort of signing up for any SaaS software, there's a small checkbox and there's a small I agree to the privacy policy and the terms and conditions. And 99.9%, I think, including us also, would hardly sort of open those boxes and read the long terms and conditions. We would simply just check in the box and then proceed. So will that, the question to anyone, will that also amount to a valid consent under the DPDP Act?
Yes, of course, it's a valid consent, Sumit. But if I want to be projected as a 100% ethical organization, I will have that 5 pages of consent, legal consent. But I will put the key points in a highlight as a summary at the top, that we are asking your consent, uh, and we will use your data for marketing.
Right.
Which means you agree to receive marketing mailers from us. We will not sell the data to any third party. We might use it to enhance customer experience
Right.
on our website. So I am visiting the website, and website is asking for consent. It says accept all cookies.
Yeah.
Then there is an option of modify cookies.
Yeah.
If I say accept all cookies, I am giving them explicit consent for everything under the sun.
Right.
Right? But if I'm saying modify, I want to get connected to your website, take relevant data, use the data, get information, and then come out of it. But I
Right.
don't want to be bombarded with marketing emailers for the
Right.
rest of my life.
Right.
But the third one is that if I say reject cookies, then if I say reject cookies, then the website owner has an option of uh, uh, not letting me go further on the website, because
Right.
they are saying we have cookies enabled, and once you have cookies enabled, then the website can track me.
Right.
So they're indirectly saying that we are going to track you if you use our website. And
Right.
by saying yes, we are giving them, without reading the whole 4 pages, we are giving them consent. We are agreeing to being tracked.
Yeah. Yeah.
And of course, being bombarded by marketing material. So yes, we have to take care of all this.
It's a very double-edged sword, I will say. Very interesting point, Samir. You said cookies. Again, this is one of the thing. It comes as a very ugly pop-up, which covers 30% of the website from bottom, and we would just accept all in a fraction of a second because we want to go to the content that we have been searching for. And who has the time to sort of with these so small attention spans and bandwidth available? Who has the time to read the cookie policy and see what is being collected, how it is being used? So again, while the data fiduciaries may put up all the legal forms and the check boxes to collect, but it's also on the data principal to be very aware and conscious, and maybe spend that time that what kind of consent I'm giving to the data fiduciary. For example, a very interesting illustration has been given in the act itself, saying a telemedicine app which you are downloading, and where you can consult a doctor, and it is asking for a permission to access your contact list. Now saying that this is not okay, because why should a normal consultation with a doctor app should take charge of all your contact list for their own sort of maybe marketing purposes or illicit purposes? So if they do it as a data fiduciary, it will be against the spirit of the letter in the spirit of act, because even if you give consent as a data principle, but the purpose for which they are asking may not be a sort of a lawful purpose or the most ethical purpose, and therefore those kind of data fiduciaries may be booked under the act with penalties. And why are you asking for unnecessary information which is not required for provision of goods and services or the transaction? Is that right? Is that the right interpretation, Dr. Limaye or Sumit?
Correct.
Yes, it is right. See, you have to understand from government point of view that explaining what we are discussing right now, there are about 190 participants and 200 people discussing something which is a concept, and it is difficult for us to understand, implement, right? I've been in IT for last 34 years. In the last 4 years, since we have gone deeper into this, into understanding this law, since the first draft of PDP came, I never used to read the policies, but now it has become a passion, so started reading policies. But I can assure you 99%, 95% of IT professionals who understand this, and legal professionals with whom this data is connected, they also don't read. So it's a change. Now this is for us. Now if this law talks of every individual, even a child or a minor. Imagine 140 crore people. How will you make them understand the meaning of privacy? So from a government point of view, it's a very, very big challenge.
Yeah.
99% people do not understand the term called harm audit, which means that what will my breach of data, what harm will it bring to me? Why is the government spending so much time? Why is Complinity spending so much time in explaining to me that privacy is important? Why is it important? What harm can it do to me? My number is known to everybody, right from my maid to my neighbor to my friend. Everybody knows my number. Hundreds and thousands of people know my mail ID. My Aadhaar is being distributed lock, stock, and barrel here. There, photocopies being distributed to all banks. This, LIC, this, that. Where is the loss of privacy? What will it do for me? And that's the biggest challenge for people to understand that privacy is a very tricky subject. I could go to a mall and he can ask me, please give me your number. We will send you discount coupon. I'll say, no, you will misuse it. Next day, I am in a different mood. I go to the same shop and I give my number.
Yeah.
So this is a very different concept to understand. And that's why we urge all our clients to understand that this is a change management issue. It will take years for people to understand.
Yeah, absolutely. And mobile number is the most abused any which ways. You go to a restaurant and you are in a 10-minute waiting queue. The girl standing there will ask your mobile numbers on the pretext that she will call you when the table is ready. You go to a grocery shop and they will ask your number because they want to feed into their system, not because of anything else, but so that they can put you on their SMS spam list, so that you start receiving those messages which you can't even block. So I think it's a very the pesky calls and the pesky SMS messages, it's a menace. Despite all the D&D regulations by TRAI and all those things, this just doesn't stop. Anyways, again, what will happen to the cold callers and the telemarketers and the databases? I'll tell you, again, on a lighter note, love to share these incidents with the audience. One person called me, from one of the edtech companies. I will not name because of privacy issues.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.